Good afternoon. Thank you for joining us. My name is Upasana Rao. I'm a partner in the corporate practice at the firm Trilegal. We are presenting to you a panel on the topic, the future of Fintech and PropTech in M&A and regulations. The sponsoring committees are the International M&A and Joint Venture Committee, International Private Equity and Venture Capital Committee, and Cross-Border Real Estate Committee. Well, now, according to data in recent times, despite global market conditions, the fintech sector saw significant investments across the globe, consisting of a combination of venture capital transactions, private equity, and M&A transactions, and is estimated to grow more. In the first quarter of 2023 alone, fintech was one of the most invested industries, and with over $14 billion in funding. The largest market of this is projected to be Asia Pacific, where fintech and payment sector is helping expand financial inclusion and e-commerce. North America is the largest fintech market and remains a critical hub for innovation. Similarly, for PropTech, real estate technology market, even though there was a decline in deal activity last year, overall the trend for the past 5 years has been upwards. Investment in deal activity in technology startups and platforms for real estate include services like co-ownership, listings, rent-to-buy, sale-leaseback, home rentals. These are some of the top business models that are attracting funding and is likely to see a tremendous boost in the near future. Growing use of technologies such as virtual reality, big data, AI in the real estate sector. As far as regulatory developments are concerned, there has been a common trend across various jurisdictions. There are common trends in many parts of the world, for example, stricter controls on storage and transfer of payment and digital lending data, risk management, cybersecurity, and fraud prevention. Now, I come from India, and we have a brand new data privacy law in India after 10 years of parliamentary debate. And that will impact fintech industry a lot. So fintech companies that collect and use digital personal data to facilitate payment or lending transactions may either be classified as data fiduciaries or data processors, and depending on the activity, and then will be subject to high levels of compliance. But in most countries, the collection of personal data requires consent, and the data can only be used for the purpose for which consent was taken. As far as access to funding is concerned, again, this is a function of state-level incentive plans, foreign investment rules that incentivize or debt or venture capital investments, and access to the capital markets. As far as licensing requirements are concerned, in most countries, there are licensing requirements for financial services of different degrees. Back in India, there is no common regulation for fintech services. There are different rules that apply for financial services products like payment solutions, e-wallets, digital lending, and crypto. Again, the crypto assets regulations for crypto assets across jurisdictions is similarly developing. In certain countries, it's far ahead. And as far as government support is concerned, regulatory sandboxes are in most Asia Pacific countries to foster innovation in fintech. Another trend that we've seen is also cross-border regulatory cooperation for anti-money laundering measures. Domestic laws in most countries require the reporting of suspicious transactions in the payment space using fintech platforms. An interesting case that happened in India, because I come from India, is that a recent court judgment where PayPal was held to be a reporting entity under the anti-money laundering laws of India, which now requires it to comply with a lot of regulations and invest in some digital infrastructure for storage of data. Now with that, I will hand it over to our panel speakers with a quick introduction. We have Jun Young Kim, a distinguished senior attorney at Kim & Chang, who serves as the driving force behind the firm's fintech and blockchain practice group. With a profound involvement in pioneering initiatives since the inception of the fintech blockchain industry, Mr. Kim extends invaluable guidance to prominent domestic and international entities within the fintech blockchain landscape. Sitting next to him is Dong Lee. Dong Lee is partner and head of White & Case's Korea Corporate M&A and Private Equity Practice Group. Donggo advises Korean and global clients, including many of the largest Korean conglomerates, technology companies, and international and domestic private equity firms on cross-border M&A transactions, strategic alliances, joint ventures, and ESG matters. And then we have Wong Jun Lee, who has extensive experience in cross-border transactions. He has served interesting clients involving assets amounting to multi-billion dollars throughout his legal career in various capacities. He's currently serving as foreign counsel at a global EPC contractor based in Seoul. He will be presenting on legal strategies and use of fintech in cross-border real estate M&A. So over to you, John Young. Let's start with your slides.
Thank you, Prasanna. Good afternoon, everyone, and thank you for joining us today. It's an honor to be here today to discuss the future of fintech, and especially in the context of M&A and regulations. First, allow me to briefly introduce myself. I joined Kim In-jang in 2010 and have been deeply involved in M&A transactions since the beginning of my career. And not long after I started, I found myself captivated in the rapidly emerging fintech industry. And over the recent year, particularly since 2016, my professional scope naturally expanded to the blockchain. So I'm truly excited to share insights on today's topic with all of you. And today I'll be discussing the unique regulatory challenge that arise in M&A projects related to fintech and blockchain. In particular, I'll be delving into fintech and virtual asset service provider regulation in Korea and future legislative plans. So for fintech, I'll be discussing the consideration when establishing a new company in Korea for fintech business or when acquiring a company with a fintech license. And I'll touch upon the licensing issue and the consultation process with financial authorities. Additionally, I'll discuss the recent amendment to the EFTA passed by the National Assembly. And when it comes to virtual assets, I'll provide an overview of the current regulation, notably the AML Act. I'll also shed light on the recently passed Virtual Asset User Protection Act and share insights on the upcoming legislative plans. So I believe understanding these regulations is crucial for anyone engaged in fintech and blockchain industry, and including those involved in M&A. So I hope to provide a helpful overview today. So moving on to the next slide. Moving on to the next slide, let's delve into the fintech regulation, focus on the license issue and the consultation process with financial authorities. This is particularly relevant when considering the establishment of a new fintech company or acquiring an existing licensed company in Korea. First, the license issue is vital, especially when considering the establishment of a new co that will engage in fintech business. While this license issue is significant, during the due diligence process of acquiring a fintech company, it's even more critical when setting up a new entity. When establishing a new fintech entity, specific licenses or registration may be required under the Electronic Financial Transaction Act, EFTA. For instance, if you're venturing into the payment gateway, PG, or prepaid electronic payment means, PPM sectors, certain permits or registrations are mandatory. To provide a bit of context for those unfamiliar with this concept, payment gateway in Korea can be loosely equated to payment processing services in the US. And the prepaid electronic payment means in Korea somewhat resembles e-money services in the EU. And however, it is crucial to note that these comparisons are not exact, and each system has its unique characteristics and regulatory frameworks. For those considering the domain of virtual asset service provider, a vast report under the AML Act is essential. This report operates similarly to a de facto license, since regulatory authority must accept the report. However, if obtaining a direct license seems daunting, there are alternatives. One such option is partnering with already licensed companies, which can provide a smoother entry into the fintech market. When pursuing such a partnership, it's essential to clearly define the roles and responsibilities of each partner. Essentially, companies without a license should be structured in a way that they don't engage in activities that would trigger license requirements. And second, I'd like to discuss the unofficial consultation process, a crucial aspect when acquiring licensed companies. When contemplating the acquisition of fintech licensed companies such as PG, PPM, or a vast reported company, it's noteworthy that no separate prior governmental approval is needed for a change in substantial shareholders. However, it is crucial to emphasize that even though it is not a legal requirement, engaging in prior consultation with financial authority is highly recommended in practice. There is no set timing for such consultations, but it is common to initiate engagement with the regulator around the signing phase. During these discussions, regulators typically focus on details about major shareholders and business plans, with a particular focus on any circumstances that might impact the target stability, while also considering the potential effects on user protection. By understanding these processes and requirements, business can navigate the fintech landscape in Korea more effectively and ensure compliance with all regulatory standards. Now let's move on to the next slide, where we'll explore the recent developments in the fintech regulatory landscape. Let's begin with the current status, where we have seen a significant development. The proposed amendment to the EFTA has received the green light from the National Assembly as of August 24th, 2023. This is a key moment, and we are looking at a timeline where this amendment will come into effect by September 15, 2024. So there is ample time for business to adapt. In the context of M&A, it's particularly crucial to conduct a thorough review of the target existing business model and considering the forthcoming EFTA regulations. Checking whether additional license might be required or if modification to the business model are necessary to comply with the new regulations should be an essential part of the due diligence process. This proactive approach not only facilitates a smoother transition, but also mitigates potential regulatory risk post-acquisition. Now let's discuss the implication of this amendment. Firstly, the PPM, the prepaid electronic payment means, is seeing broader horizon. We are not just talking about the inclusion of electronically converted paper type PPM, but also a shift in the business categories. The two business category distinction is on its way out. So previously, only PPM that could be used in more than two business categories were subject to PPM regulations. But now, even PPM that can be used in a single business category are regulated. And the exemption for PPM licenses, those are becoming more stringent, expanding the scope of entities that will require a PPM license. And moving on to the buy now, pay later, or BNPL service. Currently, it operates under a sandbox mode, similar to the sandbox system in the UK, which temporarily exempts innovative financial services from certain regulations. However, with the upcoming amendment, this is set to evolve. If you're a PPM service provider and you're eyeing the BNPL market, you'll soon be able to engage in the BNPL business, but with a catch. You'll need prior approval from the FSC, Korea's primary financial regulatory authority. And importantly, these PPM service providers will be restricted from using their prepaid fund to finance the BNPL business. And lastly, the user. The amendment is putting the user front and center. It mandates that at least half of the user funds must be managed separately through trust, deposit, or payment guarantee insurance methods. Moreover, it includes scenarios where the entire balance of PPM must be refunded to customers if the number of merchants where PPM can be used is reduced without a justifiable reason. The amendment also introduced a financial soundness requirement to further protect users. These updates underscore the government's commitment to fostering a secure and innovative fintech environment. As we navigate these changes, it's essential to stay informed and adapt our strategy accordingly. Moving on from fintech regulation, let's now shift our focus to the next slide where we'll explore the evolving landscape of virtual asset. Starting with the current legal landscape, the amended AML Act, which came into force on March 25th, 2021, has brought clarity to the realm of virtual asset. It not only defines what constitutes a virtual asset, but also introduced the concept of a virtual asset service provider. Diving deeper into the implication, let's first understand what a VASP is. Broadly speaking, a VASP is any business that professionally engages in virtual asset-related business activities. While the legal definition is quite broad, as you can see, traditionally, the financial authority have viewed centralized exchanges, custody services, and custodial wallet services as the primary subject for VASP reporting. However, recent interpretation and rulings have expanded the scope of what constitutes a VASP. It's also worth noting that this definition includes foreign VASP involved in cross-border activities. Therefore, even if a foreign corporation conducts business in Korea, it must file a VASP report. And as mentioned earlier, for a VASP to operate in Korea, it must file and have its VASP report accepted. Non-compliance isn't taken lightly. Failing to file a VASP report can lead to severe consequences, including imprisonment up to 5 years. In practice, two major hurdles often arise during the VASP reporting process. While obtaining the Information Security Management System (ISMS) certification can be time-consuming, it's not typically a decisive barrier. However, securing a real name verified bank account from a bank, which is essential for services involving crypto fiat transaction, proves to be a significant challenge. Banks have been notably cautious, often reluctant, to provide such services to VASP, making it a substantial obstacle for VASP intending to engage in this type of business involving crypto fiat transactions. But the regulatory framework doesn't stop at VASP reporting. VASP also has AML requirement to adhere to. This includes customer due diligence, filing suspicious transaction report, and more. On the other hand, financial institutions like banks are instructed to either decline or terminate transactions with non-registered VAS. And lastly, the AML Act also sets forth specific requirements and restrictions on VAS business activities. This includes segregating customers' funds from their own funds and restriction on transaction with unregistered VAS and limitation on certain self-building activities. And building on our understanding of the current regulatory landscape, let's shift our focus to the upcoming changes in virtual asset regulation. Starting with the latest development, the National Assembly passed the Virtual Asset User Protection Act at the end of June this year. This significant piece of legislation is expected to come into effect in July 2024. And diving into the implication of this act, it's noteworthy that there won't be a separate license regime other than the VAS report under the AML Act. This means that the terms virtual asset and VAS will retain the same definition as provided in the AML Act. This act primarily addresses two main aspects. Firstly, it aims to protect users' assets in VAS. Secondly, it prohibits unfair trade practices. To safeguard users' assets in VAS, the act mandates both the segregation and protection of users' deposit and the safekeeping of virtual assets along with other regulations. In terms of preventing unfair trade practices, the act introduced regulation aligned with security laws, such as prohibiting the use of non-public information and preventing market manipulation. And lastly, looking ahead, there are ongoing discussions regarding broader legislation. While the current AML Act primarily addresses AML concerns, and the Virtual Asset User Protection Act focused on user protection and unfair trading, there has been a continuous call for more comprehensive regulation. This future legislative plan is expected to encompass additional aspects of virtual asset industry, including virtual asset issuance, disclosure, and other sound market practices. Both the regulatory authorities and the National Assembly are actively discussing the introduction of comprehensive regulation for virtual assets. And given the pace of these discussions, we anticipate a more detailed regulatory outline to emerge by this year's end or next year. In summary, we have navigated the dynamic world of fintech regulation from the current state of affairs to the anticipated changes on horizon. The domains of fintech and virtual assets are not only rapidly evolving, but also growing in complexity. From the viewpoint of M&A, especially in sectors like fintech and blockchain, where regulations are quickly taking shape and changing, keeping a close eye on these regulations and understanding their implication is paramount. Also, engaging in strategic discussion with regulatory authority to precisely understand the license and compliance requirement is crucial for businesses. It's evident that as the fintech and virtual asset industry matures, so does the regulatory framework that surrounds it. Staying informed and adaptable in this dynamic environment is not just advisable, but imperative for all stakeholders. By keeping up with the evolving regulation, we can ensure that our organization and clients not only comply, but thrive in this new era of digital finance. Thank you for joining me on this exploration, and I hope it has provided valuable insight into the ever-evolving world of fintech and virtual asset. With that, I'll wrap up my portion of the presentation. Thank you for your attention, and I'm confident that other speakers will provide further valuable insights in the next segment. Thank you.
Thank you, Jim. Very comprehensively covering the regulations in Korea. And now I invite Dongbo, who will speak to his experience and trends in fintech in other jurisdictions.
Yeah, hi, my name is Tomo, and I'm a partner at White & Case, and splitting actually my time between New York and Seoul. I'm supposed to be 50-50, but due to COVID, it's more like 70-80, so 20-30 in New York. But anyway, once I got the invitation to speak at this seminar, in thinking about the deals that we have done, and I guess today I will focus more on just observation and trends, and also the role of Korean players in the global fintech market, which is actually quite interesting. So moving on, personally I've been done, payment gateway and other e-commerce and blockchain and DeFi, crypto kind of deals, mostly in the US for Korean clients, but also in somewhat random jurisdictions like Vietnam and Kenya and other jurisdictions, because there are many interesting Korean tech companies. So just to give you some flavor, there are a lot of Korean conglomerates, like Samsung and LG, SK, those big conglomerates with technology kind of departments. So they've been historically doing a lot of fintech payment related deals in the investments in the US, and joining them more like traditional financial institutions and their asset management arms. And they've been investing in similar sectors overseas. And what complications for those Korean financial institutions that they are actually operating banking operations in the US and other jurisdictions. So in the US, when they make investment, they are actually subject to bank holding company, for example. So they are subject to all kinds of US banking and other financial regulatory related authorities and their supervision. So there have been that trend, and there are also key clients and VC clients and a lot of the blockchain clients making investments. So in some of the Korean, especially payment gateway and e-commerce clients, they invested in Southeast Asia also. There was a huge trend. Initially started with China, so many Korean tech companies, they invest in technology in the US and grow their business in Korea. And once they are done, they basically penetrate in Chinese market first. And then because of the geopolitical tension, Korean companies are no longer making any investment in China for the most part, and they quickly moved on to many Southeast Asian countries like Vietnam. And they basically exported their existing business models in terms of payment gateway and e-commerce related business by doing an M&A transaction. For example, in Vietnam, we have one actually a key VC client who did a successful acquisition and exit in Korea and Japan, and basically acquired a Vietnamese fintech company, and they injected their other business kind of units into Vietnam and made it successful, and they're in the process of sale right now. So those were some of the trends that we have seen. But interestingly, in probably since last year, we see actually decreasing interest in Southeast Asia because of some of the political issues and kind of like unstable legal system there. Because although some of the Southeast Asian countries are parties to the New York Convention, so their court system is supposed to enforce commercial international arbitral award, but in some jurisdictions they don't really enforce. It's extremely difficult. So it's also known kind of facts that some of the Korean conglomerates, it took them more than 10 years to enforce any judgment, and sometimes they fail. And so Korean, especially private equity clients and some of the asset management companies and financial institutions who used to do a lot of investment in Southeast Asia, actually kind of pulling out of Southeast Asia. But there's increasing interest in India, and so that's some of the kind of trends that we have seen. And Kenya and African countries is another interesting market for Korean tech companies because they have done trials and errors in Southeast Asia, and they now have their own technology. And they have acquired technologies from US targets. They are trying to find a new market. And Kenya, I've been to my best kind of business trip ever to Kenya with a client. It was a fantastic trip. Monday through Friday, tough negotiation, and Saturday, Sunday, we went to safari with client. So it was fantastic. There was like giraffe and zebras outside my hotel room. So Anyway, so to me, I have done several deals in Vietnam in the fintech industry, and Kenya felt really similar to Vietnam in a sense that the population in Kenya and some of the African countries are really young, and then they do not have access to the traditional financial system. So they don't have bank accounts. Many of them do not have bank accounts. They don't have credit cards, but everybody has mobile phones, and everybody's playing games on their mobile phones. And since they don't have credit card and they don't have bank account, they actually use some kind of top-up services. So what they mean is that they basically get mileage points on your mobile phone account, and sometimes they can top it up at just convenience stores, and they use their phone to buy anything, buy food, and do e-commerce. So there is a huge mobile-based e-commerce industry in African countries, including Kenya. And so what our client did is actually they developed an app out of Korea, and they launched the app in Kenya so that people can use their mobile phone mileage point to buy Bitcoin. So that's kind of strange, but that has been going on, and people actually, there are increasing interest, especially in Kenya, because it's an English-speaking country, and relatively speaking, the political system is stable. So we have seen a lot of companies like Microsoft sending their engineers and training their engineers in some of the African countries like Kenya. And so we have seen some inflow of Korean engineers and fintech companies going into like Southeast Asian countries and now African countries like Kenya. And while discussing this kind of interesting trend, but still my kind of bread and butter is outbound investment and M&A for Korean clients going into the US. But as we all know, there is increasing kind of emphasis on CFIUS, the Committee on Foreign Investment in the United States, and there are similar foreign direct investment related restrictions in many countries, including we started with US and then Germany and other countries, and we now have a deal in Hungary, and they have similar kind of CFIUS type of approval process in Hungary for any foreign investment for controlling control state kind of deal. So there's increasing kind of a protectionist kind of regime in every country, and fintech industry has been actually one of the key sectors that Biden administration has been actually focusing on. And there was actually an executive order by Biden, basically directing the CFIUS, which is a collection of 17, 18 different agencies, to focus more on fintech-related M&A transactions in the US, and it identifies certain risks and also direct the committee to basically consider certain factors. So we do see increasing kind of scrutiny by CFIUS in fintech transactions, which means that it is actually becoming kind of more difficult to do deals in the US. So from Korean clients' perspective, still Korea is not China, so we have done deals in other sectors, including nuclear and defense industry for Korean clients in the US, but we haven't seen any kind of mitigation kind of measures, or we haven't seen any deal blocked by the CFIUS or US government. So Korea is one of the key ally countries. So we haven't seen any deal block or kind of issues from CFIUS filing kind of perspective, but the timeline became much longer, and we do see a lot of questions towards Korean buyer in interesting questions such as, hey, what is your affiliates do in China, and what is your affiliates business in Russia kind of question. And if you consider any of these big Korean conglomerates, they basically do everything and anything under the sun in just so many jurisdictions. So making those CFIUS filing, collecting information is a massive task. So that's what the client is aware of the US market in terms of CFIUS and also in other countries. So our own Whiting case actually do have a publication called Clubs and Fences, which captures all those foreign direct investment related restrictions, not only in the US but many other countries in Europe. And I don't think we don't practice Korean law, so we default to Kim and Jong and others, but we cover most of the other jurisdictions in our publication. So in terms of those restrictions or practical obstacles to do fintech related deals, another thing is the common theme has been AML, and we do see similar issues in opening of a bank account. Oh, we don't have much time.
You can tell us the slide.
Yeah, still talking about it. So we have seen increasing issues, practical issues in terms of KYC and AML kind of issues. And moving quickly to the regulatory arbitrage, kind of a random term, but since Korean tech companies has been doing deals, as I explained, in the US and Vietnam and African countries, and they actually adapt to the new, the changing regulatory regimes quite quickly. So once there is political tension with China, they invest in Vietnam, and if Vietnamese core system is not reliable, they quickly move on to Africa. So we do see really kind of responsive and flexible tech companies and their investment appetite. So to me, it's almost like regulatory arbitrage, especially in the industry sector related to crypto assets. And some of the same blockchain clients that we have been advising for a long time. Many of the Korean companies have actually relocated to Singapore because there was Singapore Monetary Authority's kind of guideline many years ago, and now Singapore government is adopting more like a US style kind of approach, and they will, regulate as if they are securities, and the restrictions, they now have more restrictions in Singapore, and we do see a lot of Korean clients, and I'm not quite sure whether I can call them Korean clients, Korean CEOs and founders and engineers, but they are moving from Singapore to UAE because there is in effect no regulations, and in terms of AML and all that, it is not as restrictive. So not a good thing, but many Korean clients are actually moving on to UAE. And then, but we do see some interesting development, for example, in Hong Kong. Hong Kong has been losing ground to Singapore as like financial hub in Asia. And Hong Kong didn't have any guidelines regarding crypto assets or any related regulation, but Hong Kong Monetary Authority last year actually declared that they will come up with policy regarding stablecoin, and they plan to actually introduce a legislation early next year. So there is a movement. So we have seen like Canadian client doing stablecoin kind of business in Canada, moving on to actually Hong Kong. So we do see a lot of like migration in different jurisdictions. So these people are quite flexible. So anti-money laundering is a common issue, and also our colleagues, speakers have already mentioned. So nothing really new, but the second main bullet point is we do see increased level of enforcement actions in the US. And I mean, my colleagues are, for example, representing FTX in Bahamas, and we do also represent Celsius. So a lot of crypto-related bankruptcy cases are going on. And well, I will defer to Kim and Chan, but some of our crypto and fintech-related clients, some of the very interesting ones are actually under fire in Korea. There is a new administration, and there is kind of a political war going on, and a lot of prosecution of crypto industry players in Korea. So I have seen some clients just wasting a year just responding to government audit and government investigation. In the end, no charges has been filed to our clients, but there is a lot of enforcement actions going on. not only in the US but also in Korea. So that's kind of a common theme. Yeah, and some of the other issues, you know, as all we are practicing lawyers, you may as well just well aware of these issues, but some of the key kind of more like due diligence issues in fintech M&A deals for Korean clients, you know, same old data privacy, you know, after the EU level GDPR, we have seen increased level of state regulation in the US. So yeah, we understand the latest in Indiana, following Utah, California, Colorado, Connecticut, Virginia, like consumer protection related data privacy law. So has been a big issue, and cybersecurity has been a key kind of legal area that we focus on. So these are some of the you know, more typical due diligence issues. And yeah, and I will end. I guess we don't have much time. I will end with some of the challenges that we face, and since yeah, this now goes back to the role of Korean players in the fintech market. Is Korean clients, there are a lot of technology accumulated in Korea, and then they are pretty active investors in the US in terms of acquiring technologies. So as I mentioned, there are like conglomerates and private equity funds and financial institutions all quite actively doing deals in the fintech industry. So they play a key role, and Korea has been kind of like gateway towards the bigger Asian markets. So if you consider the domestic Korean markets, smaller, much smaller compared to China, India, or Japan, but it is almost 100% cross-border kind of economy. And the Korean economy itself is like 70–80% export-driven economy. So we are the gateway to introduce you know, new fintech kind of business model to other Asian countries. So it is kind of becoming the test bed. So in that sense, we are actually making profits by doing that kind of arbitrage again from a commercial perspective. But from Korean tech clients' perspective, we do not see, you know, coordinated approach in terms of regulatory kind of framework in Asia or globally. So everybody is struggling. So we do see increased level of activities by more tech companies, but not by the financial institution, because they are affected more by the government, and they are more conservative and subject to, you know, Financial Services Commission and other regulatory bodies in Korea. So that's something that we wanted to mention. And then, you know, when I first heard about this seminar, you know, I was wondering to myself, you know, fintech, what kind of fintech sector are we talking about? There's like open banking, and there's payment, and there's crypto, and there's all kinds of stuff. So it is quite broad area, but one common theme is that the regulation on these fintech-related sectors are not that, you know, well established yet. So there are, you know, a lot of, you know, migration, as I mentioned, and then, you know, we, as Mr. Kim mentioned, that there is the similar securities regulations type of concern, like market manipulation, and those investigations that I mentioned in Korea was focusing more on market manipulation of coin price and things like that. And so this fintech industry people you know, just reflecting on my clients, they are all former investment bankers spending time in the US and Hong Kong and Singapore now in the fintech industry in Korea. So these people are aware of the, you know, the traditional securities regulation and financial services regulatory regime, but they are trying to find a way to do new business. So that's the challenge and also the opportunity for the clients. So that's what we have seen. And the last point, yeah, just we have done many deals for many of the major Korean banks in recent years. One kind of common kind of problems that they face is that, again, Korea is really cross-border and export-driven country. So many of the Korean major banking institutions, they have operation in the US. So they always have local rule issues and, you know, Bank Holding Company Act issues. And some of the Korean banks, they are major lenders and they are entering into venture capitalist kind of business sector, investing in fintech industry. So sometimes they convert their debt to equity. So without even knowing it, they sometimes just violate the bank holding company act related restriction and all that. So this has been kind of common theme, and some banks have been actually subject to FINMA, enforcement action, SEC regulatory actions, and they do receive letters from SEC. What are you doing? So yeah, that has been the common theme in Korea. So just wanted to mention that, and so I guess that's it for my session. Hopefully it was interesting kind of observation. Yeah, I guess I hope that added something regarding the deal flow and market trends and legal issues that we face in doing this. Thank you.
Thank you. Thank you for sharing your practical experience and the challenges. May I invite Won-Ri, who will speak on cross-border real estate M&A using technology and fintech.
Right, I will take just 2 pages for the remainder. My great pleasure to be here to give the presentation to the distinguished audience, and also speakers. Well, disclaimer first, this presentation does not constitute legal advice for which you will have to get independently. We already had a variety of promotions about the religious affiliated themes already in this conference time. And let me fully disclose my motive behind this delivery. My personal motive is first, I'm Christian, and I'm providing this presentation for the glorification of my Lord Jesus Christ, up there sitting at the right hand of God. I duly suggest you read the Bible, the Word of God, to know the truth carefully, as Jesus loves you all. Whether my presentation is short or long, okay? And my professional motive is this. I'm trying to promote American Bar Association's Cross-Border Real Estate Committee, which is CBRE in short form. And its lawyering activities thereof. I mean, the CBRE is expected to grow rapidly with more opportunities. As the world can have the blockchain technologies. Third, I use the ChatGPT 4 for developing a small portion of this presentation. So this is another disclosure I need to make. Actually, this disclaimer and the disclosure are actually the prelude of the key takeaways I wanted to have. The disclaimers are the very important things to your legal practices still in the blockchain world. I think even more so than outside of it. So if you do not have enough time to finish the session, you are partially okay to leave now. On the first page, the title of the slide is Overcoming Challenges in Cross-Border Real Estate Fintech, or CLE. The moderator of Sana, to my right, she actually coined the term, I think, in the editing process, so I appreciate it. The moderator of Sana did it, and maybe we should, I think we can have another subcommittee named after that, CLE. Since our audience is mainly comprised of the practicing lawyers, this first slide is the most relevant and actually will carry the day, I think. There is probably nothing better than having a real-life case study for developing our practices with this educational delivery. Let me provide you with a detailed US example of how a US CBLEF company operates this day, utilizing blockchain technology. Other slides will be shared or uploaded for your references and for more of the holistic disciplinary aspects. But I'm sure this US case study will provide you with all the good tools to begin with for the understanding the picture in a holistic way. More formally on my ABA-IELS committee cross-border real estate, the co-sponsoring committee of this session is the ABA's International Sections cross-border real estate committee, which was very keen to support this session, as this is a very opportune time for more of the lawyers, especially the cross-border M&A sector lawyers, as well as fintech with a fintech background. As you see, other related cross-sponsoring committees are also involved in this session. You all are welcome to join and develop this uncharted or not fully charted water. If you have done some M&As or are interested in doing so, or even just some real estate investment transactions, you are already fit for the CBRE committee. So you are welcome to join our committee. In America, when it comes to the cross-border real estate transactions, developers in a state or a country often incorporate an LLC, an incorporated entity, and solicit foreign investors to buy securities, the stocks of the incorporated LLCs or the other forms of the entities to be managed by the developers themselves. The reason why is that sometimes it's easier to find and able and willing foreign investors without having to overcome cumbersome regulatory requirements, both onshore and offshore. The regulatory requirements like heavy filing with the SEC I'm talking about. And the selection of target investors also depends on the respective market circumstances. In terms of the economic considerations, America is a favorite destination for real estate investors, especially for those located with high or super annual inflation rates. I was personally involved in cross-border real estate M&A as a legal counsel / broker / prospective investor when Bitcoin was not as famous as today. Actually, it was a few years ago, though. But it was an esoteric process for not only for laypersons or in Korea, but even for the lawyers that are not familiar with cross-border real estate transactions, at least in South Korea. And the developer of the project was based in Florida, America. Favorite destination of both domestic and foreign investors. And he had to draft the offering memorandum, partnership agreement, which is the constituted instrument of the established LLCs, and operating agreement, which is the bylaw of the LLC. And the difficult part was to find the investors located overseas. As a cross-border M&A lawyers do not necessarily find drafting those instruments that are quite standardized to my knowledge. So to find the investors, we had to have contact points in target foreign countries and could remotely solicit investors from Florida, making phone calls and distributing flyers all in compliance with the applicable security laws. Well, respective foreign countries' prospective investors had to also get counsel from local lawyers in this regard as well. And while all the papers are done, the difficulty lies just finding prospective investors outside of the domestic territory, America. So we had to pay also in addition to that, we had to pay for the middleman taking brokerage royalties as well. So and the time came for the prevalence of the blockchain technology now. And one American Florida-based platform company got my attention, and it revolutionized after me, but by himself, it revolutionized the whole process with the new technologies, including the blockchain technology, and definitely the fast and easy and worldwide online transactions there would help them grow and help their customers transact all the real estate transactions at ease at their fingertips without having to consult with their local lawyers. While lawyers are still doing the same work, drafting the same types of instruments with the added blockchain elements to it, the drafted instruments are publicly available on the company website. I will not disclose it without written permission from the company though today. Well, to the point, it's all about the regulations are relaxed for this type of the cross-border real estate transaction, where you're trying to sell your domestic land or the buildings, or your plan of doing so, plan of developing a building on the land. Well, you can incorporate a company and sell the company that will manage your plan or manage your houses with the land to have your revenues from the rents from those real estate assets. But you can sell your stocks of the managing company to the foreigners, right? So when it comes to the foreigner-only investors transaction, then the regulation S in the United States of America's securities laws apply to that specific type of the transaction. So among the extraterritorial application of the American laws, including the securities laws, as a government entity, you tend to extend your power across the border when you can, whenever possible, but often the reality is that the government entity does not necessarily have the resources to enforce their enabling acts and regulations thereunder across the borders, even when they can do so based on the laws. So this principle has been personally observed myself in terms of, among others, labor laws, intellectual property laws, and here securities laws. Understanding this, the U.S. securities laws provide exceptions to the rigorous compliance rules when it comes to securities transactions involve only foreign investors. The exception is called Regulation S. The Regulation S means what to you? To me, as a son of God, like Jesus is to us, forgiving all. So the foreigners will buy the land promised by God. As you know, often the land of the USA is called a promised land. Foreigners and aliens, in the American legal terminology, you might think it would be too expensive to own American land or house, which is also legally classified as real estate. The good news to them is that blockchain technology enables you to own at least a portion of the ownership interest in the land or house in the promised land. So here's the brief ChatGPT 4 free version definition of the brief introduction of the Regulation S of the Securities Act of the United States of America. Let me read if you allow. Regulation S is a regulation under the United States Securities Act of 1933. It was established by the U.S. Securities and Exchange Commission (SEC) and provides a safe harbor from the registration requirements of the Securities Act for the offerings and sales of securities that occur outside of the United States. Regulation S outlines the conditions under which certain offerings and sales of securities to foreign investors are exempt from the registration requirements. The regulation is divided into several rules that specify the criteria that issuers and sellers must meet to qualify for the exemption. These rules generally pertain to, first, offers and sales. Regulation S provides exemptions for offers and sales of securities outside of the United States, ensuring that the transactions do not involve U.S. investors and do not have a substantial connection with the United States. Second, conditions for the exemption. Issuers and the distributors must comply with specific conditions, such as ensuring that offers are not made to U.S. persons and that there are limitations on resales of the securities to U.S. persons for a certain period. The primary goal of the Regulation S is to facilitate the raising of the capital by U.S. and foreign issuers in the international financial markets without subjecting them to the extensive registration and disclosure requirements of the Securities Act. However, issuers and market participants must carefully comply with the regulations provisions to ensure that they qualify for the exemptions outlined in Regulation S. So of the ChatGPT information, to be noted is that the Regulation S does not have any exceptions or additional requirements on the use of technologies, including blockchain or augmented reality or everyday online purchase of the tokenized shares. You can just follow the spirit of the Regulation S with the new technologies. So how do we get into the promised land? The Regulation S will take you there. In the traditional cross-border real estate transactions, again, lawyers are involved in making sure a special purpose vehicle is incorporated first in offering memoranda, partnership agreements, subscription agreements, and share purchase agreements are aligned with the applicable laws. In the same way, cross-border real estate transactions with blockchain technology can be done in a very similar, if not the same way. Surely, as long as the purchases of the shares of the special purpose vehicle are familiar with the new technology. And let me add my personal opinion. I'm done with the one more paragraph. So regulation S will be applicable to US persons as well. This is my projection. Regulation S type of the regulations will be applicable to US persons as well if the use of the new technologies will be proven safe enough by numerous cross-border transactions. As the Bible reads, like Jews will come back to Jesus if enough Gentiles will accept Jesus. I think it's reasonable to predict that foreigners buying US real estate by means of blockchain technology could be enough to show that such blockchain-involved transactions are safe enough. But domestic US persons may want to buy the same land or house in the same way the foreigners would buy it with the new legislation rendering the regulation as applicable to the domestic US persons as well. Otherwise, the US persons within the meaning of the securities laws of the US still have to comply with the regulation that's. Here's the last analogy I'm making, which the D stands for the test of price to me. Thank you.
Thank you. We have a few minutes for questions if there are any from the audience. No questions? Thank you for attending. Thank you to all panel speakers for their comprehensive presentations, and thank you for the time from the audience.